Hello, I am Amar Twayna, student ID EMB24500. I am explaining about the issues and rules about the case. First of all, the issues arising out of the current case are whether Frederick Forthright is liable to any contract, uh, and if any contract is binding on him, then which one is enforced. Now, we move on for rules applicable. A valid contract is formed when all the essential elements of the contract like agreement, consideration, legal object and intention of the parties are present and offer is accepted, such in case of Australian Woolen Mills Private Limited and the Commonwealth. However, in case of auction, bidding is not considered as an offer, but it amounts to invitation to offer as in AGC Limited versus Macro-Realtor. In case of height and range, the acceptance is given by the other party is imposing some modification of the terms of the offer, then it can't be considered as an acceptance. Instead, a counter offer is formed, and main characteristic of the counter offer is that it kills the original offer and the states of fresh offer. Another important quality of a valid acceptance is that such acceptance has to be communicated to the offerer, otherwise it has no effect as in Brescian and Squires. Uh, however, in case of postal service, there is a different scenario where an acceptance is said to be done in the valid way when the letter containing the acceptance statement is posted as in Brickborn Limited process, that's Staghack Stall. In case of Adams versus Linsell, it is not taken into account whether the acceptance is being communicated or whether such letter gets lost or delayed after its posting. In case of Todd and Nicole, if the contract involves any commercial transaction, then it assumes that the parties have lawfully intention to effect it. Order to aspect of the valid contract are consideration and lawful object behind the creation of the contract, which if not present will lead to the formation of void contract, as laid in this Popui versus Popoi. Similarly, if object is illegal, then the contract is void, as in South Australian Coal Stores Limited versus Electricity Tours of South Australia. Thank you.
Hello, I'm Suraj Karanjit, bearing student ID EMV 24461. I'm gonna take the application part from here. In this case scenario, the author named Frederick wanted a publisher to get his new book published, but he did not want the old publisher, the first one, the Metro publishers, because of their ill treatment before. Then in a party he met with the chief editor of Boswell Publications, who offered him a price of 40 grand for publication of his second book. So the amount which was dealt was just a verbal agreement, social agreement, so it lacked legal intention of the parties. Then on March 3rd, the editor of Metro Publisher again approached Frederick to publish his second book with an offer of 50,000 grand, to which Frederick did not respond. He told he's gonna think about it, so the offer was not accepted, so the contract therefore was not formed at all. Then again on March 4th, he got an offer of $45,000 from Havoc Films to make a film on his first book. Then Frederick made a counter offer to select the cast in the movie. So the counter offer destroyed the original offer which was made before. And on March 10th, he got an offer letter from Boswell to publish his book for $40,000, which he bargained to $45,000, and then he signed it, but he kept the letter with the postal officer, but asked him not to post it yet. Then when he came back from immediately from the postal office, he met with a renowned publication pick, publication author Pickwick, who made an offer of $45,000 for publishing his second book, and even offered him a check of $45,000. So he went back to the postal office and asked the postal officer to get back the agreement which was sent. So therefore the agreement was not sent. Then Frederick signed the check and took the check from the Pickwick publication, which made the contract valid, and it was then we can conclude that Frederick Forthright made a valid contract with Pickwick by signing the check and receiving the check, and such contract with Pickwick is binding on him, and it was enforced when Pickwick handed him the check after accepting the offer. Thank you.
Hello, I am Puspa Niroula and my student ID number is EMV24510. Today I will be discussing about the issues arising out of the present case involving Mercedes. That is, whether she had committed any breaches of statutory duty or general law duty of care and diligence. The second issue is whether she is liable under section 182 of the Corporation Act, and if she is liable under section 588G if the company turns insolvent. The rules applicable for this case are the present case scenario has to be analyzed in the light of the provision enumerated in the Corporation Act 2001, which lays down several duties of the directors of any company. Section 181 of the said Act provides the civil liability of the director of the company to act and perform their duties with reasonable diligence and care. In any case, any director fails to act with care and diligence in a reasonable manner, then he will be responsible for infringing the provisions of section 181, as in ASIC versus Casimat 2016. Section 182 enumerates that when a director is made liable for the violation of section 181, then the director involved in such scenario may protect himself by pursuing the bid business judgment rule given under this section. It states that director is said to be safeguarded by the application of the business judgment rule when it is seen that he has taken a particular decision for adequate reasons and in good faith without having any conflicting personal interest with topic of the decision. The section has been constituted in ASIC versus RIS 2003. Another duty of company director is being provided under section 588G of that similar act. This section enumerates that if a director cannot prevent accruing debts when he is already aware of the fact that the company is going to be insolvent or ready to be insolvent in the given situation, such director will be held responsible under this section provided debt did occur when he was the director of the company, which turns insolvent or may become insolvent for it. Here, the director has acted with malafide intention and dishonest intention, and hence did not prevent the company from turning insolvent. Section 588S provides the defense which any director can seek for protecting himself when he is liable under section 588G. This was entitled in Hall versus Pullman 2007. Thank you.
Hi, I'm Suraj Dahal and my student ID is EMB24564. Today I'm going to talk about the applications for option 2 part B. So in this case, it is seen that Felix has a belief that the company Joytronics must shift to a larger store located in different area of Sydney. Without having any formal discussion with Mercedes or Greggs, he planned to scout around the new store. Mercedes was not sure about the decision of moving out to the new store, and she believes that they shall spend enough time to consider other options. But because of various reasons, Mercedes became stressed out and did not perform her duty as the director of the company, for which the financial condition of the company became worse. This amounts to infringement of Section 181. She did not act with care and diligence, for which the company suffers financial loss. Moreover, the fact that they consented with Felix in spite of being unsure results into infringement of Section 182, as she cannot apply the business judgment rule. Moreover, Mercedes was aware that the company was in financial problem, and if any decision is taken without considering, this may cause the company to be insolvent. This showed that Section 588G was violated because she had not taken any reasonable steps to prevent the company from being insolvent. She will also not be able to protect her interest as per Section 588H. So from this, what we can conclude is, Mercedes, being the director of the company, has called the infringement of the statutory duty of care and diligence given under Section 181. Moreover, she has also breached Section 182 because of her decision to give consent for buying new premises. Moreover, in case the company becomes insolvent, then she will be held liable for breach of Section 588G. Thank you.
My name is Sandesh Subedi and my student ID is RI2533. So today in this presentation I am going to talk about the scenario 2, question number B. So in this case the issue is that the first issue is that whether Craig has breached his duty of care and diligence of the company, or he has any liability if the company has been declared insolvent. So this is the issue for this case. And in the next slide, the application part. So here the Greg was a school dropout and has no high school education certification. So in spite of that, he has the practical knowledge and the of the product and product of the company, and he also has the all the knowledge about the warehouse of the company. And the other case is due to his lack of knowledge and experience. For all the board meeting and decision making process, he has to totally dependent on two director of the company, Felix and the Mercedes. So considering those facts, this cannot be made liable for the violation of Section 181 and 588G. So this was the application part. So for the conclusion here, as we can see in the slide, Greg has not caused the breach officially due to care of diligence, being the director of the company, and moreover that Greg has got no responsibility even if the company becomes insolvent. So this case is clear. Greg has no any liability over the company because he was not certified and then he had the less education. So this is the case. This is all.